Okay, being in Florida, I'm a probate attorney, estate planning attorney in Florida. Florida, obviously, a very popular destination for people to retire in, to have second homes in. But how does that work with regards to a probate, right? A lot of times, just as an example, we'll have somebody who, maybe they've got a house in Palm Beach, a house in Miami, or a house in Sarasota, somewhere in Florida. And maybe that's a part-time, maybe it's a full-time, but they're also a resident somewhere else. Maybe they're a resident of New York, New Jersey, California, Texas, wherever. They're a resident of somewhere else, or maybe they even die in another state, but they have a physical asset, or they have some asset in Florida. Where do you do the probate at? And so what we're going to do is we're going to look at first, where were they a resident at? Okay, that's because generally, if you're a resident of a state, that's where the first probate's going to be opened. So let's say in this example, someone is a resident in New York, all right? But they have assets in Florida, but they're a resident of New York. Well, we want to first know, is there going to be a probate in New York? So do they have a house in New York? Do they have bank accounts in New York? What do they have in New York? Maybe all of that stuff has beneficiaries on it. Maybe it was in a trust in New York. So no probate's needed, right? So there is not going to be a probate in New York because everything was titled appropriately and we don't have to do one. But they have a house in Sarasota, Florida, and it wasn't in a trust and it wasn't titled correctly. So now it has to go through probate. In that case, we're just going to have to open up a probate in Florida. So even though they were a resident of New York, and let's say they even died in New York, but they had that house in Florida, or a lot of times we see people just have a piece of vacant land in Florida that they've owned. It's been passed down through generations. They just had a piece of vacant land. Well, just for that vacant piece of land, you're going to have to do a probate in Florida. But what happens in that example if they had a house in New York and they had a house in Florida, and the house in New York wasn't in a trust? It didn't say who the beneficiaries are. The title was just in their name. And the same with Florida's property. The house was just in their name, not in a trust or anything like that. In that case, you're going to have to do two probates. The first one's going to be in New York because they were a resident of New York, right? So that's their primary residence. So that's where the initial probate's going to be opened. Once that one's opened, then we're going to have to open up a second one in Florida for the house that's in Florida, right? And that's going to be called an ancillary probate, which is a second probate. So it really depends on, if you are a resident of one state and you've got assets in another state, you might have to do two probates. You might only have to do one. But again, the key is hopefully you can avoid that. Hopefully you can plan for avoiding that by doing a trust or some sort of estate planning, because as you can imagine, two probates can be expensive, two attorneys most likely, and then the headache of just having to go through all of that. So again, we've got a lot of clients that are, part-time residents of Florida, or frankly, they're, passed away in Florida, but the kids live elsewhere. So check out our website, probatefirm.com. We got a lot of great resources on there to learn more about the topic.